Any adjournment request?
Good evening. Leave it. Yes.
Daily list for orders, item 1.
Yes, Mr. Naik.
Lordship, this is a review petition.
Hmm.
Lordship, kindly see the order at page 23.
Page 23.
Yes, Lordship.
Yes.
Lordship, in fact, on 1/4/2025, when the instant matter came up for consideration, I mean, the appeal came up for consideration. Lordship, an additional affidavit filed by the writ appellant was considered. And on the basis of that additional affidavit, Lordship, this matter was decided.
That's right. But then look at this. Now, no order was passed.
Yes.
Now, why do you worry? What gives you that red signal? Why do you see the red herring here?
Lordship, but just one document I would like to place, Lordship.
No, I'm asking a different question.
Yes.
Now, agreed that the writ petitioner misled the court. He did not correctly state the facts. He did not talk about anything.
Yes.
The question is that you are in possession.
Yes.
The irrigation office is there.
Yes.
The court says he himself, the writ petitioner himself says that no, it's not, nothing is required.
Yes.
Now they have located to another place. Now, can your possession be divested
Lordship.
by a private writ petitioner?
Lordship.
You say lordship. I'm asking you a question.
My understanding is that, Lordship, if the incorrect fact is allowed to remain in the record, Lordship.
But nothing has
that
been
may
done,
in
no?
future prejudice me, Lordship.
It only says, accordingly, in view of the fact, as per additional affidavit filed on behalf of appellants, when the respondent department has already vacated the land. So that's a claim which is not existent. So it does not give him any right. Nonetheless, we'll have the course correction. Otherwise, it's bad.
Yes,
no?
Lordship. That is what I only want, Lordship. If one page, Lordship, I would like to say.
Then that's right. No. So therefore, why?
Lordship, in fact, this plot of land was mutated in the name of irrigation
That's
department,
right.
Lordship. And that was way back in the year 1968-69 on the basis of an agreement executed in 64.
But then you should have been more careful, Mr. Naik. You should have been more careful.
Lordship.
Now, these kinds of innocuous petitions keep coming to the courts.
Yes, Lord.
And especially when the court does not have to adjudicate, then perhaps the petition is disposed of without looking for the counter affidavit. But you should be careful because any time a writ petition is filed, the copy is served in the office of the Advocate General.
Yes.
And that's distributed to the concerned advocate who is to,
Lord.
who is to address
One
the
of
court.
my colleague appeared in this matter. In fact, no affidavit was.
And this is response that he got confused with certain communication and all that. That is not done. Difficulty here is that all this was available to you. If we strictly measure it in terms of Order 47, Rule 1, then your revision may not be maintainable.
Yes.
But we understand because there is some suppression of fact. There is some, I mean, we can smell the rat here.
Lordship.
Like here, the state is in review against a judgment dated 1/4/2025, passed in writ appeal number so and so of 2023. The respondents here, the respondents/writ petitioners preferred an application seeking intervention of the court and direction to the respondents, appellants herein, petitioners herein, to either release the land belonging to them, which was alleged to have been acquired sometimes in the year 1965, or pay reasonable compensation for the land so acquired. Before the matter could be adjudicated and the petitioner/state could file counter affidavit, an additional affidavit was filed intimating the court that the land in question has already been released by the state because the office of the irrigation department has relocated somewhere else. Considering this a statement as a correct exposition of fact, the appellate court disposed of the appeal, holding that no order is required to be passed. First up, it is also required to be noted here that the writ petition originally was dismissed for the delay in approaching the court and for not bringing in necessary materials in support of the claim that the land in question was acquired and no compensation was paid to the landowner. The fact is otherwise, which finds mention in the present review petition. The contention on behalf of the petitioner / state is that the claim of the writ petitioner that the land was vacated is absolutely false. The statement was said to have been made on the basis of some communication made by a clerk in the revenue department. However, the fact is that the executive engineer of the concerned division confirmed that the land remains in the possession of irrigation department without any unauthorized occupation or encroachment. Additionally, it has been brought to the notice of this court that a draft chitta from 1968-69, which could be collected, indicates that the land was transferred to Jamuna Irrigation Office by the registered deed dated 26th of October 1964, executed by the writ petitioner's grandfather, late Makram Ali, grandfather Makram Ali. The contention of the petitioner is that the land remained under their possession since 1964 and no effort was made by any one of the heirs of the landholder to have any compensation paid or the land be returned because it was not used. It was only later in the year 2021 that rent was deposited for the year 2013-14. On record, Mr. Nayak asserts, Mr. Nayak for the review petitioner asserts, there is one complaint made by the writ petitioners in the year 1995, but the state has seriously challenged the authenticity of the aforenoted complaint because it was not signed. This review petition has been filed only for the reason for the correction of the statement of fact said to have been made with respect to the land in question. That apart, the writ petitioner, according to the review petitioner, made misleading statement, perhaps for the purposes of taking advantage of such litigation, such orders in litigation for taking possession or attempting to take possession or to attempt to take possession of the land in question or to manage payment of compensation for the said land. Let notice be issued to the respondents herein. How many of them? One.
No, Dr. There are 7 in total now.
Respondents herein on steps being taken by the petitioner, review petitioner within a period of 2 weeks, both modes returnable January.
Obliged.
Land revenue.
28 January. 28.
We call it rent.
28. 28. Item 2.
Lordship, here my
Yes, Mr. Cal.
writ petition filed by the union was allowed.
Hmm.
Lordship, I was praying for seniority from the date my junior was promoted. in page 31, page paragraph 30, while allowing the writ petition, this honorable court observed that my senative will stand as
Now, that's a
serial number
separate
5.
cause of action if at all it exists.
Lordship,
Mr. Kayal, that's a separate cause of action if at all it exists. Now look at this. Now
Lordship.
there is no doubt about this, the correctness of the decision.
Lordship, I'm not challenging that.
Now we followed.
Lordship,
Try and understand in the perspective in which I'm trying to tell you.
Lordship,
Now you applied for the post of section officer on
Yes.
deputation. If you had to be treated as a departmental candidate, then perhaps this was a promotion.
Lordship,
So this definition was not there under the rules of 2001.
Lordship,
It was only in 2018 that the new rules came amalgamating all
All the
the
private-
establishments.
Lordship,
But so far as you are concerned, you yourself admit that you wanted the deputation charges to be paid to you.
Lordship.
Therefore, for all practical purposes, you were only on deputation for
Lordship.
3 years or till further orders.
Lordship,
You continued there. Correct? Now, with the new rules having
coming to force.
holding the field, that is 2018, where the controlling officer is the
DRT
is the
Kolkata.
DRAT,
Kolkata.
DRAT chief, Kolkata. Now, he is the controlling authority.
Lordship,
So even otherwise, according to the service jurisprudence, a common seniority list, civil list was prepared where you rank somewhere as assistant only.
Lordship,
Now, the only thing that you can now say that because of the others having got promotion on the basis of, what is it? NVR, not below, next below,
Lordship,
next below rule. That's a different cause of action. Now,
Lordship,
I review here.
Lordship, Lordship, I know the legal position, Lordship, but here in paragraph 30, this honorable court observed that I stand at in seniority, common seniority list, I stand at 5 Lord.
That's
But
good.
below 6, all nowadays, Lordship, 13% has been promoted after me, Lordship.
That's what I'm saying. You see, what happened is that you were posted as section officer, you continued in that post. Now with this judgment, because it was not taken to be promotion and deputation, you went back to your substantive post of
Lordship.
assistant. DP. Now you were at Cuttack and you are now being transferred to Hyderabad.
Hyderabad.
So that's a problem we can understand, but what can be done in review?
Lordship, at least.
I think the correct course of action on your part would be to withdraw this review petition. Otherwise, we'll dismiss it on merits. Withdraw this writ petition in order to file a separate writ petition for before an appropriate forum for giving you the benefit of next below rule.
Lordship,
We'll indicate that in
this-
our
Lordship indicate.
Take it. The review petitioner had applied for the post of section officer under the DRT, under the, which rule that? Under the, as he applied for the, as a legal, we have heard Sri Kayal. We have heard Sri S.C. Kayal and an advocate for the petitioner. Next, the petitioner had applied for being appointed as section officer under the recruitment rules of 2001 for deputation or on deputation. The rules specified that if any candidate was a departmental candidate, any candidate selected was a departmental candidate, such appointment would be deemed to be promotion. The eligibility for such appointment was 8 years experience as assistant. The petitioner was returned successful and was appointed on the post of section officer at Guwahati. On being asked, he desired to have his appointment treated as deputation, and he claimed deputation charges as part of his salary. Later, the rules underwent a change, and a common rule was framed in 2018 amalgamating all DRT institutions, including DRAT. With the new rule, a common seniority list of assistants was published, wherein the petitioner was shown as an assistant at a particular serial number. The petitioner therefore approached this court for a direction to treat his, approached the tribunal for a direction to treat his appointment as a promotion and not by way of deputation. So he was strengthened to file such an application on the basis of a favorable report by the chairman of the DRT Guwahati. The tribunal, considering the recommendation of DRT Guwahati, allowed the OA application and held that the petitioner be treated as petitioner's appointment be treated as promotion and not deputation. So this view was upturned by a division bench of this court on the reasoning that the very appointment under the rules of 2001 was on the basis of the petitioner having applied for appointment on deputation. The later developments and the option exercised by the petitioner also confirmed the same. It was only much later that the rules underwent a change in the year 2018, with all entities having been amalgamated into one. One of the rules in the newly framed rule of 2018 provided for a common cadre list of assistants. It was only for this that the petitioner had approached the tribunal. The bench of the High Court found that when the petitioner was appointed, the DRTs at different places were distinct entities, and therefore the petitioner could not have been treated as a departmental candidate. The rejection of the claim of the petitioner by the DRAT Kolkata for his appointment to be treated as promotion was thus sustained. The petitioner, unfortunately, had to go back to his substantive cadre of assistants, and post the judgment of the High Court, he was posted as an assistant in DRT Hyderabad. Mr. Kayal submits that under the new rules, there is a provision for promotion under the next below rule, bracket NBR. And on such principle, many juniors or peers of the petitioner have been promoted to the post of
Section officer.
that all. क्या लिखा है? Next below rule. And since many juniors of the petitioner have been promoted to the post, he also deserves to be given that benefit of promotion to the post of section officer, as he has worked on that in that capacity for several years. We are of the view that this would be a separate cause of action which cannot be agitated in the review jurisdiction. Not finding any error apparent on the face of record in the judgment which is sought to be reviewed, we were inclined to dismiss the petition. However, on the asking of the petitioner, on the asking of the learned counsel for the petitioner, we permit him to withdraw this petition in order to agitate his claims before an appropriate forum. The petition is withdrawn with the liberty of consent.
Much.
Item, sorry. Item 3.
Yes.
Please, your lordship. My lord, in this instance,
Hmm.
the issue in question is relating to an order passed by its honorable court relating compliance by the executive authorities
Hmm.
with under section 14, my lord. Normally, my lord, there is no quarrel with the proposition that this is not an
That's right.
adjudicatory mechanism.
Yes.
But the issue was that in 18th of March, well before the writ petition was filed, the person, my client's co-owners had already filed a representation before this deputy commissioner as well as before DM, stating that they were co-owners.
How does it make a difference, sir?
My lord, because they said that they are taking possession of the entire land, my lord,
That's right.
and partition.
But then that issue, can it be decided by the collector?
My lord, it was not decided by the collector,
He has to just see and verify the
Yes.
conditions under 14.
my lord.
Correct.
So the constructive note possession was already taken beforehand, my lord. But thereafter, when the
But
section.
your option is to, I mean, the best option for you and the only option for you is to go before DRT. You can be restored your possession,
My lord,
not here, not
my
here.
lord, I will not be restored. I'm not seeking my possession.
Oh.
My lord, because the honorable court directed for taking possession, therefore, my lord, the honorable DRT could not give me a relief
No.
unless in this case.
No,
my
no,
lord-
no, no. DRT operates in a different field.
my lord,
This direction was only for observance of the ministerial function which a DC or a CGM has to do.
Yes, my lord. But my lord, because this observation was made on the basis of a concealment of a fact, my lord,
That operates in a limited sphere.
limited sphere, my lord. But my lord, in this case, my brothers have already filed a writ petition which has been informed to me seeking that they were intentionally not kept part of this writ
Can
petition
that be-
before this
can that
honorable
be-
court.
Can that be called a suppression? No, look at this.
Well-
We are faced with this kind of situation. Normally, if it would have been brought to the knowledge of the judge,
Yes, my lord.
perhaps some time would have been given or he would have been asked to. But no, the law says, SARFAESI law clearly states that
Yes.
these, co-ownership disputes,
Yes,
title disputes,
Yeah.
they cannot derail a DRT proceeding. A SARFAESI proceeding.
my lord, that is not being derailed, my lord, because the bank has themselves participated before the title suit. I can show, my lord, they have appeared before the honorable civil court. They have refrained from participating thereafter. They have taken time to file an objection and they have thereafter not participated because of this order dated 18 June 25. They have submitted to the jurisdiction of the civil court.
No. He can. See, you're barking up the wrong, tree.
My lord,
You have to go before DRT. That's the only thing. Take that.
my
What's
lord,
your name?
my lord, grant me the liberty to approach the honorable DR.
You have the liberty, we'll say that.
Yes, sir.
But when you file a petition, we will, either you withdraw or we decide it on merits, then no review.
My lord, then my lord may grant me the liberty to approach the DR. Withdrawal with liberty.
But then, because you have to go, I'm told by my brother that you had approached DRT.
Yes, yes.
They dismissed your.
They dismissed on merits on
You have to go before DRT.
DRA, my lord. My lord, but that is not an order
That's-
arising out of the DRT's order.
This order, they'll have to deposit some money. But then there is a rule which says that it could be relied. And I have also passed the judgment that in such cases where they are not party, they have not the loan. No, he's brother. He's the brother.
No, my lord,
You're the-
I am the borrower. I am the borrower.
You're the borrower.
I am the borrower.
Then.
There is no equitable mortgage.
Then-
My lord, again,
Then
another
you
aspect.
have no case. We should not have allowed you to even open your mouth.
No, my lord,
I thought
there is
you were
no
the brother of
mortgage
the
in
borrower.
this. There is no mortgage.
Sir,
My lord, I'm stating
please
this
withdraw
on
this
record.
petition, otherwise you'll say that everything is false.
My lord, there is no mortgage at all. That is the second leg of the argument, that there was no mortgage.
That argument, before making that argument, you must go through the Transfer of Property Act.
My
Which provision?
My lord, the equitable.
There is no need of any separate
Yes.
mortgage deed.
There is no need of any separate.
If there is a delivery of title documents and there is an intention to create a mortgage,
There is an
that's
intention.
good enough.
Yeah.
You know the judgment, you
Yes,
know
my
the
lord.
law.
Yes, my lord.
And which provision says this?
My lord, I'm not
All
remembering the provision at this moment.
Provision I would also not remember, but then 58F,
58.
58F of Transfer of Property Act, read with section 2ZF and 13 of the SARFAESI Act. That's absolutely clear. You have not withdraw this petition or we order
My lord may permit me to withdraw this.
Mr. N. Barua.
N. Barua.
Your Barua.
N. Barua.
Mr. N. Barua, learned advocate for the petitioner, review petitioner, after some argument seeks permission to withdraw this application, withdraw this review petition in order to agitate his claim before an appropriate forum. Dismissed is withdrawn with a liberty of force.
I brought you.
Item 4,
2 days delay. Notice pending delay. It's a 2 days delay, no?
Yes, ma'am.
We condone the delay.
I do not have a copy of the IA, madam.
We are telling you 2
Malus,
days
malus,
delay,
malus,
condone it,
malus.
contest it in appeal,
Malus.
contest it in review.
Malus.
Sorry. Write the order for the reasons stated in the application. The delay of 2 days is condoned. The application stands allowed. The registry to process the review petition, get it listed.
28/1. Same date. Same. no? Item number 5,
212 days, notice there.
Lordship, I may be allowed to introduce petition.
Good. You are Mr. Mukul
Dekar.
Deka.
M. Dekar.
Mr. M. Deka, learned advocate for the petitioner, seeks permission to withdraw this application. Dismiss was withdrawn. Yeah. Yes.
adjournment request if any, from item number 1 to 5. From item number 6 to 17. Adjournment request.
Please allow.
Yes,
I beg to mention item number 16 and 17, my lord.
both.
Both your lord.
All right. What is it?
My lordship, we have to file a reply in this matter.
What is the point involved here?
My lordship, the reply
In the
is.
matter of selection, we wanted some, journal.
Yes,
Can
sir.
you have a vested right? Because you print a journal, it must be subscribed to. Can you say that?
Lordship, kindly grant me 2 weeks.
We grant you time, but why keep this burden on the list? Anyway, today we will not disappoint you. We are granting you time, but then you don't have anything here. What is your name?
As Gautam, your lordship.
Mr. Gautam, you are an advocate for the petitioner. Seeks adjournment in this matter. Let this in case come up for consideration. Then it goes in January, we will see. Sometimes in late January, alag order pass karna and list both the cases together. Deeply aware.
30th January 30.
Yes,
From item number 18 to 23, adjournment request.
20 and 21.
Item 20 and 21 adjournment slip has been.
Yes, adjournment slip circulate on behalf of the respondent, on behalf of the respondent.
Petitioner, Lord.
So why don't you stand on your place?
I'm sorry. 2021.
We have
I'm sorry. 20 and 20.
with the consent of the other side. We will fix it.
My
If
lord,
there is no urgency, it goes in January,
in-
otherwise December.
My lord, item 21 from, both the matter from CAT, item 20 and a small issue.
What do you want?
My lord, in the first week of December, can it be?
First week of December. Both.
Obliged.
Of 21 in first week of December. First week of December, we are not here. Second week of December.
Obliged.
Second week of December and 20, item number 20, you're appearing in item number 20.
20.
Oh, that goes in January.
That.
20 January.
Obliged.
May it please your
Yes,
lordship. Lordship, in regard to item number 23, lordship, I would like to seek for a short accommodation for a day.
My lords,
There is.
I have an objection, Lords. I appear for the appellant.
In this matter, what they're doing, my lords, there's a roads construction contract.
Yes.
My lords have taken up the matter for admission in the past. Every date they come, they'll say 39% we have completed, 50% we have completed, and they're stalling the matter for them. My lords, I very humbly request, yesterday they had sought for my consent, my lords, I had objected. And I said that I'm not providing my consent. My lords may kindly take it up for hearing. If not today, then tomorrow, my lords. If they have some inconvenience, and if not inconvenience,
There
my
is
lords,
great inconvenience.
my lords may kindly take it
There is
tomorrow.
real convenience for today or for all times to come?
No, Your Honor, like we seek 2 weeks time because my.
2 weeks is
2
too
weeks,
much.
my lords,
And
it is
don't-
inordinate.
No, just a minute. You can't force it down her, no?
No,
She
I
has come
cannot.
with instructions from a senior. She has to say,
I understand.
now, 2 weeks' time, we grant you, subject to the caveat that you would not take this plea that the work of the respondent I mean, it has progressed to 50%. 39% we remember.
No,
Yes.
Your Honor, like
Yes.
in the events, there had been subsequent rainfall, I know, so like the work construction has also stopped during that time, Your Honor.
That
There
may be
has
reflected.
been much development also regard to that.
This
Just
is
2
the
weeks.
same matter which if
Yes, yes, my lords.
correctly, the
My lords
matter,
are absolutely correct.
where post
Yes.
technical
They
withdrawal
changed the entire selection criteria, my lords.
weightage of marks.
Yes, weightage of mark.
But why can't it be done?
My lords, because the QCBS methodology, the GFR specifically provides it has to be incorporated in the tender itself. In our case, tender does not have any indication that QCBS
May
will
not
be.
have. But then for evaluation, if this process is adopted,
Yes.
what is the harm? Where is the objection? Where is the legal impediment?
The objection is that the ITB had to specify it. The ITB says that the
That's
lowest bidder
not
will.
specified, because no numbering,
Yes,
nothing is being done.
yes,
You have crossed that threshold,
yes, my lords.
correct?
Yes,
So financial bid also,
yes.
your
Ours was
bid
the
is-
lowest, my lords.
You were the lowest.
Yes.
That is not a consideration. It's not necessary that the lowest bidder.
No,
has
the
to be given-
ITB says that lowest bidder will be selected. my lords.
No,
That
no,
is the
how can-
problem.
How can that?
My lords, it says so in
Then-
27.1,
they-
clause 27.1.
The very ITB is incorrect.
No, my
This
lords.
can't be.
If that would be the case, because then the entire contract will go, they will have to retender, my lords. That is not what I'm on, my lords.
ITB says that the lowest will get.
Yes, yes, clause 27.1, my lords. It says so, that the lowest bidder, after the technical bids are substantially compliant, which is the case across the board, the lowest bidder will be selected. That is the case, my lords, under 27.1.
All right, 1 week last indulgence, not 2 weeks. Who is appearing? Who is leading you?
My lord, my senior from Koima, Mr. Mua Jamir.
But then he can appear virtually.
Yes, my lord. This
There
week,
had
if
been
not
some-
inconvenience.
Mr. Counsel, don't, I see, if you insist more than I grant,
Very,
then I grant time.
I
That's
apologize.
something which I do not like.
very good. I
There must be
apologize.
some difficulty.
My lords will pardon me. My lords will
We
pardon me.
do grant adjournments considering the difficulty of the lawyers. Now, you would be on this side someday.
Yes, yes.
So therefore,
My
don't
lords,
be
with
so.
apologies, next week, my lords, I have some inconvenience, my lords, which is only why I had indicated. So
You can
otherwise,
appear virtually.
lords,
Now, 2 weeks, we are not granting, 1 week. All right, 1 week.
Because if the observation may be made, Millards, regarding the work, Millards have very rightly indicated the 39%,
And
because that is the plea that they'll take, Millards.
you
That we have,
address the matter without the hands of the other side tied in the back. No observation. Okay. As prayed for on behalf of the appellant, as prayed for on behalf of the respondent, let this matter come up for consideration on, give a date next week, Monday. No further adjournment.
Millards, Millards, can it be Friday, Millards? I very humbly request, Millards.
So it
next
was the
week,
next
Friday.
Friday,
Yes,
not this Friday, next Friday,
next Friday, Millards, next Friday.
28th. All right.
Grateful.
28th, then you're supporting a prayer. 2 weeks.
Because next week, Monday, I have some personal difficulty.
All right.
I'm,
So therefore, you should not have objected so much, no?
I was objecting for this week, Millards. I'm grateful.
Deeply obliged.
So and so. No, then we don't write no further adjournment. We will not grant adjournment.
Yes.
That's all right. We are not saying this. All right, yes.
Much obliged.
Grateful.
Any other request?
Lordship, item 22.
22,
Twenty.
early birds. Yes, what do you want?
With the consent of the other side, the conducting council is.
As
unable
prayed
to
for
agree
on
to
behalf of the
What?
petitioner, after taking consent from the lawyer for the respondents, let this matter come up for consideration January.
29 January. Any other request? Daily list for orders, item 1.
My lord,
Mr. Roy, you have not taken any.
my lord, in this case, Mr.
Dasgupta has he requested us to serve copy on him. He said we have already served copy on the junior Mr. Dasgupta.
Why has the office reported that you have not taken steps?
Well,
to issue
Mr.
the
Dasgupta
notice?
is here. no?
Yeah, you're here. Ready?
I have to file an affidavit. yet.
Huh?
Small affidavit, ma'am.
You file, you'll file. So they're fixing a date. You can file an affidavit in between. Can I have your name, please? Mr. A. Dasgupta. Here. Notwithstanding the fact that no steps were taken for issuance of notice to the respondents, Mr. A. Dasgupta, senior. Mr. A. Dasgupta, learned senior advocate, has appeared on behalf of the respondents. He has submitted that he shall be filing a short affidavit in response to the memo of appeal. Let this matter come up for consideration on sometimes in January.
After 20th.
Let this matter come up under the appropriate heading, bracket admission on so and so day.
1st of February,
Let it be after 15th.
As you wish.
1st of February. Item 2,
Yes,
May please, your lordship, this is a transfer, this matter has been transferred from the Honorable Manipur High Court.
yeah.
So we are ready. It may be fixed for hearing, but the opposite party has not appeared today.
Tell us whether others have appeared. If anybody has appeared, otherwise.
No,
also
your
it's
lordship,
fixed
as
for
per the
hearing.
order sheet, on the last 2 dates,
Hmm.
neither party had appeared, but today we are appearing. They have.
No. Have the notices been served?
No,
There's
sir.
no idea.
It's a pending matter, your lordship. The writ appeal was already filed before the Manipur High Court. It could not take it up there.
But then, see, once it has been transferred here, they have to be noticed that they must come.
We'll intimate the council and.
Please
Manipur-
intimate the council.
Yes,
Council here. These set of appeals have been transferred from Manipur High Court. Stop. The learned counsel appearing for the appellant submits that he shall intimate the learned counsel appearing for the respondents in the matter about the next date. List this case under the appropriate heading on, give a date in January. List all these matters and so on so. Yes,
21 January.
Oblige, your lordship.
Item 3,
notice served. Are you appearing?
I am from Tesla number 2 and 3.
And who is the other respondent left?
Respondent, I think number 4 has been left out actually. The
Number 4,
statement-
has he been served?
Lordship, I have filed a affidavit for
Apna-
compliance of dusty service.
Name appears for respondent number 4. No, none appears for respondent number 4. Can you? Can I? Apne wala.
Lordship, Lordship, I will file a reply.
Mr. Mazumdar,
Yes,
can you inform respondent number 4?
yes,
He
of
has
course,
been served. Maybe respondent number 4 would engage you only.
I can. I will
Because we will hear it on the next day. Yes, what do you want?
Lordship, I will file a reply.
Reply to what?
Respondent number 2 and 3 has filed a affidavit.
Reply to reply is generally a rejoinder.
Rejoinder.
Take note. Mr. I.S. Mazumdar, learned advocate, has appeared for respondent number 2 and 3. He has also filed a response affidavit with the writ petition. He has been requested by this court to intimate respondent number 4 to appear on the next date. The learned counsel for the petitioner, however, wishes to file rejoinder to the counter affidavit of response number 2 and 3. Let that be done on or before the next date. Re-notify on. Give it.
Oblige.
8th of January. Item 4,
कल वो judgment ले लेंगे. Yes, what is it? 473 days, coming for the first time.
Yes, ma'am.
Coming for the first time.
First time.
You want to
Lordship,
respond?
Yes, Lordship, we would like to file an objection because against a common order, single writ appeal has been filed, which is not.
The
Sir,
learned counsel appearing for the respondent wishes to oppose the application for condonation of delay of 473 days. For the aforesaid purpose, he seeks a short adjournment. Let the objection petition be filed on or before the next date, pre-notify 4 weeks.
Publish.
Published.
9 January. Item number 5.
This delay of 39 days coming for the first time.
All state respondent,
Yes.
all state respondent.
Yes, Lordship.
So we condone the delay.
Yes.
Lordship, I would like to file an objection.
What, for 39 days? For 39 days, don't linger it.
Published.
You can take time when the matter is listed.
Yes.
लिखे detailed heard Mr. Ken Chaudhary, let's see for the reasons stated. Delay is condoned. Heard both of them. दोनों का नाम लिखो. पूरा detail लिखो जो. The field to be processed.
19 January.
Regular order which I passed, huh?
Item 6.
23 days.
Hearing your lordship, delay is 23 days, your
Same order condoned, appeal to be processed.
lordship.
I objection, Lordship. There is no explanation, nothing.
Mention
Kindly
para
read the
2 is
para
there,
2,
your
Lordship.
lordship.
23 days, what will you do? Your matters are not taken up in 23 days.
Your lordship,
Both
one more thing, your lordship.
Yeah? What is it? Your application has been allowed, sir.
I am for the respondent number 9, Lordship.
Acha, other respondents?
Other,
All state respondents and you private.
I am only by
Give your appearance slip. You have opposed it, we have understood.
obliged.
Same date. Item 7 and 8.
No, not necessary. We'll hear both. If situation so arises, we will pass different orders in different PILs.
My lord, but the subject matter is complete.
Let it be your, it's a PIL.
But there is nothing in relation between the two matters itself, because one-
Doesn't matter. Doesn't matter. We'll pass separate orders, but PIL would be heard before us only.
yes, my lord.
So,
Only, Lordship, item number 8, I have a humble submission, my lord.
yes,
Lord, affidavit of the respondent is very necessary, but till they will not file affidavit.
they'll file it, but today we are
No,
dealing
no,
with,
no, only.
we are dealing with your interlocutory application for segregating these things.
No,
not
I'm
necessary.
saying, I'm in the respect to item number 8, man.
We have followed it, so let it come.
Only their affidavit, my lord, is Lordship filed.
Nothing.
My lord, dates may be.
PIL number 11 of 2024 and PIL number 6 of 2024, though dealing with distinct matters, have been tagged together. A prayer therefore has been made in PIL number 11 of 2024 to separate the aforementioned PIL with PIL number 6 of 2024, which have unnecessarily which are unnecessarily listed as analogous cases. Since both the petitions deal with public interest litigation, it shall be heard by the same bench, which is DB number 1. Thus, no order is required to be passed in the aforementioned interlocutory application. If the cases deal with different matters, separate judgment shall be delivered in both the.
My lord, date may be given.
With the
Date for the next hearing may be given. A date for the next hearing may be given.
let both the PIL petitions, both the PIL petitions on. Give a date in January.
21st January.
My lord, my prayer, my lord, action will be given to the respondent file affidavit, my item number 8.
Sorry. Yes.
Obliged, obliged, your honor. Deeply obliged.
For admission, item 9.
May please, your lordship. Lordship.
Where is the judgment which we delivered?
Yes, your lordship.
The only difference, your lordship, is that was an engineering college and these two pertain to 5 polytechnics.
Necessary changes, necessary changes in terms of this order.
Lost.
All right.
Obliged, your lordship.
Item 11 to 13.
One increment would be.
इसका last order मतलब the supposed to bring.
Where is Mr. Khataniar?
Lordship, I'm appearing. Lordship, on behalf of Ms. N.T. Khatri. Lordship, sometime may be given Lordship to file a reply, Lordship.
We have asked you a very small question. I don't think this, because this litigation is because of you. Your fault. Mr. Khatniar had to find out how many persons are left who have been appointed prior to 3/7/2012, and they would be required to be paid one increment for their having acquired a higher degree.
Lordship, as per my instruction, Lordship, 271 persons are left, Lordship.
Only.
Yes, Lordship.
But why do you take time? You should have taken instructions rather. Rather than instruction for taking time, you should have taken instructions to argue the case.
Lordship, Lordship, I have the instructions, Lordship.
What is the instruction that you will pay?
Yes, Lordship. Lordship.
So we allow the petition.
Lordship, I have just received it, Lordship. Lordship, sometime, Lordship, 5 minutes may be given, Lordship.
All right. Put it on oath.
Yes, Lordship.
Put it on oath, we decide the application.
Yes, Lordship.
I think it's better. You end the litigation. There are only 271 of them. And this will be over for all the times. Correct?
Yes,
So
Lordship.
put it on oath, based on your statement on the next date, we shall dispose of the writ petition, allowing it. As prayed for on behalf of the respondent, re-notify next week. Next week.
Lordship.
2611.
इसको खत्म कर।
Item 14 and 15.
Hello, I am for 15, my lord.
Yes.
Yes, I am 14, my lord.
Made with a lot. Lordship.
Yes.
Item 15, Lordship, we have filed affidavit with reply today, Lordship.
Ji?
Today, Lordship.
Yeah, but we don't file it across the board, we will take it back.
No.
File it across the board. What do we do? All matters are getting adjourned. These are hearing matters, no?
Admission.
Admission, but it can be sort of stamp vendors. Now, what do you want to say? We understand legitimate expectation. All of you, maybe you have passed that age where you can have that computer proficiency. Then the
In addition,
1 lakh subsist, 1 lakh
Yes.
else is dismal.
my lord. By that, I am ready to
Can
hear the case, my lord.
difficulties,
Only,
override the policy.
my lord, only one aspect, my lord, here. So far the hour, my lord, the contention was there, that the more than, my lord, 400 crores, my lord, the stamp and
So
this is
that's
stamp. It
the
is-
state to decide.
It is there, my lord, lying. So physical. So my lord, my submission was that, my lord, that has been admitted by the AG. AG there specifically stated
Let
more.
them do anything.
No, my lord,
that's-
one aspect, my lord, because my lord, I am on this, my lord, this is a very limited period, my lord, a periphery under which my lordship can interfere because this is judicial review. But the illegality, my lord, and the irrationality and the, my lord, the procedural impropriety, my lord, because the amount, whatever is, my lord, in the exchequer of the government, it is been, my lord, without any useless. It is nothing to be used, my lord. So this, my point, whenever the government is every month is, my lord, borrowing more than 300 crores rupees to pay the, my lord, salary, then what is the necessity of keeping this, my lord, amount about this?
It is up to them. You
So,
can
my lord,
plead before them.
my,
Mandamus can be issued.
my
of
lord,
this.
only one prayer, my lord. I am not against the, my lord, digital. I am always supporting the digital, but till then, my lord, this process they are selling of this physical, that will be allowed, my lord. This is only that much, my lord.
Not a-
On that, my lord, lordship had interfere, my lord, because this is ultimately economic policy. And the my lord, ultimately, everybody is suffering. State is suffering, my lord.
Go and approach them. This
My lord,
interest,
my lord.
it can be taken back.
Ultimately, the government is losing the my lord revenue. But
Government is not losing the revenue.
Because
You are a licensee, you have purchased it. It's your loss.
no, I am not entitled to purchase this amount, my lord. This physical, because physical, my lord, we are getting more commission than the digital ones.
That is
So-
no.
So, my lord, this aspect
We
also,
don't conflate two issues. Your limited prayer is that what 400 crores the stamps have been purchased, which have gone waste.
but consequential, my lord, may affect will on us also, because we are getting the very less amount of commission after the introduction of the
And
digital.
can this loss of yours be rectified by a mandamus against a policy?
My lord, if it is, my lord, some procedural, my lord, impropriety is there. It is a very vast area, my lord, where lordship can interfere. Because if somebody is affected by the decision of the government, lordship can interfere, my lord. The decision, I want to rely the one decision, my lord.
Yes.
This is, my lord, the decision on the, my lord, NCT, Delhi and the Chanjeev Alliance B2. My lord, in that case, my lord, the courts, my lord, the Honorable Justice, my lord, this Arijit Parsay and the, my lord, Kapadia, they have, my lord, rightly decided on which circumstances, under which periphery, my lord, lordship can interfere in the judicial power, my lord. So where it is specifically stated, there is some procedural impropriety is there, then lordship can interfere.
Procedural impropriety.
Because, my
that
lord, the
is what we want to
procedural
know.
impropriety had discussed in paragraph 15 and 16, where it is specifically stated, lordship, my lord, I'll provide the judgment, where somebody is affected by the policy of the decision of the government. This is also, my lord,
No.
procedural
For that
impropriety.
you go to the newer decision of case Puttaswamy versus Union of India.
Patasami says, my lord, that is also there, but the property impropriety, my lord, is procedural impropriety, is there, that is there,
That's
my
not
lord.
procedural impropriety what you are flagging.
So,
The paragraph.
paragraph 15 and 16, basically, my lord, 16, my lord.
The present trend of judicial opinion is to restrict the doctrine of community.
Because we are affected.
They could be employment for application. Because one can communicate certify the three terms to get. Because on the legality, the secondary of rationality and respect.
Who doesn't know this? So this is not a new proposition. Held out. What procedural impropriety do you find?
Because when the description of the improperty, what does it mean? It is widely, my lord, described, but if it is somebody, some group of, my lord, populace are also being affected because of the government policy, that is also, my lord, procedural impropriety, my lord. So this is, my case is that whenever the amount of rupees, huge amount, it is not that it is a small amount, more than 300 crores, my lord. Every month, government is borrowing money for the payment of salary. Why they are putting these things, my lord, without to be used? My case is this, only that to extent, my lord, the lordship can interfere, allow them to sell.
The advantages of digitizing it far outweighs the disadvantage to you or to the economy.
But so far,
Counterfeit.
But so far, well, I have given a list, my lord, out of the total 36, my lord, state and union territory. Last, my lord, only Punjab was that they are only digital. Now the second is Assam. Others are, my lord, some are providing, my lord, both the ways, and in Maharashtra, they are not providing, my lord, digital. They are only, my lord, physical because of the interest of their state.
That is why we get lesser cases of counterfeit stamps.
But the interest of
This
the
has really
Maharashtra.
worked. Yes, MS Som, what do you have to say? Yes.
But one thing, my lord, Maharashtra, well, kindly see, the Maharashtra, in their interest of the state, they are not introducing, my lord, digital, because the printing, press and editing is in, my lord, Nasik. So they don't want to be, my lord, these unemployed the people. That is why they are not taking this digital. So this is digital, I am not against even then. But my prayer is, my lord, till the completion of the process of sale, the physical that has been kept in the, my lord, exchequer of the government, treasury, the registry of my stamp, that should be allowed, my lord. Simultaneously, till after completion of this, let them proceed with the only digital. I have nothing on that, my lord.
Take it. We have. Go on.
This is 14.
Pahla corner. 14 is P. We have heard Mr. P, both the writ, the writ petition number 5572 of 2023 and PIL number 74 of 2023 have been heard together and are being disposed of by this common judgment. We have heard Mr. P. Mohanta and MST Som, learned advocates for the petitioners in the aforementioned cases. And your name?
N Bordolo.
And A. Borua.
N Bordolo.
M. Bordoloy.
N, Your Lordship.
N. Bordoloi,
Yes, Your Lordship.
learned advocate for the respondents in both the cases. The petitioners represent a society of registered stamp vendors in Assam who have traditionally earned their livelihood by selling physical non-judicial stamps and earning commission ranging from 6% to 10%. The primary grievance stems from a cabinet decision dated 15th of June 2023, mandating complete discontinuation of physical non-judicial stamps with effect from 1st of October 2023, transitioning fully to a 100% digital e-stamping system. This decision was formalized by the notification dated 23rd of June 2023 and supported by Assam Digital Stamp payment of duty by means of e-stamp close rules 2023, hereinafter referred to as 2023 rules close, enacted under sections 10, 74 and 75 of the Indian Stamp Act 1899. Next, as a transitional measure, the vendors were allowed to sell physical stamps purchased before 30th of June 2023, but only till 30th of September 2023. After this deadline, all physical stamp transactions have been barred. First, the vendors are required to convert their establishments into authorized collection centers or common service centers, thereby enabling them to continue operating under the e-stamping regime. The government, as an ameliorative measure, has also offered a one-time financial assistance of rupees 1 lakh to such stamp vendors to facilitate this transition. The contention on behalf of the petitioner is that this was an abrupt shift which has deprived them of their livelihood. The other ground of challenge is that there has been no meaningful transitional period, and that financial assistance offered is abysmally low. The petitioners have also questioned the legislation on the ground that new commission structure is heavily reduced and the total discontinuance has seriously affected most of the stamp vendors who are in the climacteric stage of their lives and some of them are differently able. The sum and substance of their argument is that total prohibition on sale of physical stamps has affected Article 14, 19, and 21 of the Constitution so far as the petitioners are concerned, especially in the wake of the rehabilitation package being illusory. The state has responded that e-stamps eliminate fraud, leakage, and counterfeiting. Even otherwise, the stamp vendors cannot claim any vested right to continue in the same profession even after the change of the rules. So far as, the state has responded, the transitional assistance is concerned, it is a matter of executive policy. The questions, therefore, before this bench is whether such discontinuance of sale of physical stamps is unconstitutional. Semicolon. It is violative of Articles 14, 19, and 21 of the Constitution. Semicolon. Whether the vendors are entitled to higher quantum of financial assistance and whether a mandamus could be issued to modify the policy to any extent whatsoever. It has been long settled that a legislation can be interfered with only if it is arbitrary, contrary to the statutes, and disproportionate. It requires no repetition that a court of law never sits in appeal over economic policy. There can be an interference only if the policy decisions are interpreted to be conspicuously arbitrary or suffers from lack of legislative competence or is violative of the fundamental rights. Next, the stamp vendors are the licensees of the state. They do not hold a vested or perpetual right to continue in the sale of stamps, continue in the business of sale of physical stamps. The continuance of a trade depends entirely on statutory rules. And there could be no vested right to continue in a trade when the state changes the licensing policy. The right to trade is subject to reasonable restrictions. And the change in the policy of the state of going fully digital, so far as stamps are concerned, is only reasonable and does not violate any one of the fundamental rights. We have tested the submissions urged on behalf of the parties from a different angle as well. Putting the legislation to the proportionality test as enunciated in case Puttaswamy versus so-and-so, citation Lelna 2017. The proportionality test puts the legislation in the ringer. Ringer is WRI. In the ringer, not RI. In the ringer of tests relating to legitimate aim of the legislation, semicolon, its rational connection with the object sought to be achieved, semicolon, the necessity of enacting such legislation, and consideration of balancing factors on all these fronts. The submissions on behalf of the stamp vendors / petitioners does not appear to be sustainable. The legitimate aim of the legislation is to provide e-stamps for the ease of business, as also to avoid counterfeiting of stamps or leakage. Stop. It has a rational connection because it is not unknown that counterfeit stamps were draining out the economy of the state. Thus, necessitating the shifting to digital mode. The balancing factor, in connection with the balancing factor, we are of the considered view that public interest outweighs individual losses, individual economic losses. Individual economic losses. The petitioners have also raised objection with respect to the quantum of financial assistance we are afraid whether we can enter into this domain especially when the state in its wisdom has already offered an assistance of rupees 1 lakh for converting the converting their establishments, converting the establishments of the petitioners into authorized collection centers or common service centers. Or common service centers. However, at this stage, we do consider that the state would do good if a training module is thought of for the desirous stamp vendors in computer proficiency or effectively running such centers. The petitioners would be at liberty to approach the appropriate authority for the same. The legitimate expectations of the petitioners of the soft landing of such legislation is not understandable. The legitimate expectations of a group of people cannot override policy decisions of the state. Thus, in totality, we find that the state is within its jurisdiction to impose burdens, and the spot would be absolutely loath in passing any order for rolling back of the policy. A strong argument was made by Mr. Mahanta that stamps worth several crores which were issued earlier are being wasted. This again is a matter of policy. In which no mandamus can be issued. On the contrary, we have found that a humane and calibrated approach has been taken by the state in providing a window to the stamp vendors which could have been, we admit, a little longer. But with the present day, a little longer, but after so many years of the policy having been rolled out, there is nothing much which could be done, except expecting in case so deemed necessary, a training module for the surviving stamp vendors. Or perhaps providing them with some kind of technical support for carrying on the collection centers under the digital regime. We thus grant the liberty to the petitioners to approach the appropriate authority for the aforementioned technical support and training, but no further. No further. We are thus constrained to dismiss both the petitions as having found no fault with the change in the policy and the legislation to give effect to such policy.
My lord, one pair, my lord. Whether I have been informed, although there is a procedure and policy, my lord, to convert the all licensee to a, my lord, digital, this is a citizen service center.
All right.
No,
It
no,
it
one
will
thing,
not
my
come in the way.
Yes, my lord, but some of the application is still pending, they are not considering, my lord, that aspect, my lord, only. The license,
That's a separate cause of action, will it?
I'm
Mas-
so deeply obliged.
Master.
Item 18 and 19.
Yeah, but the last, this is the last matter, no? Mr. Chaudhary.
Yes, my lord.
I think we have some time left. So we'll
Okay.
hear and complete this.
Yes.
So before that, we'll take up two other matters,
Oh, very well.
short ones. We'll take up those matters and then with composite mind, we'll hear both of you.
Supplementary list, item 24.
क्या है सप्लीमेंट्री नहीं नोटिस करना होगा ना 1 second.
My pleasure, Lord.
Just a minute. Give us 2 minutes. Retender. What is the judgment? Let's see. परवा का है. No, उसके कारण नहीं है. There is a communication and some judgment. इसमें जजमेंट को लिखा है. अच्छा. Order passed by the Supreme Court. The tendering authority, the tender authority will have time. Government circular dated. अच्छा, government circular dated 18/1/2018 क्या है? Right. No, circular dated, the government indicating that government circular dated 18/1/2018. वो कहाँ है? Right? 18th January 2018. क्या लिखता है 100%
Yes, true.
document actual fisherman certificate. Purchases. Yes.
But here we have challenged the repetition, the page 40, 40.
Retender.
Yes,
Challenge the retender.
retender.
That has been for a reason.
Yes,
The Supreme Court says that in every tendering document, certain clauses
yes,
named in circular. dated
yes, that
18th
is, yes,
that
that
is
is
not there in that tender. So despite your having been at
page
the highest
41.
bidder,
Another 11, page 41.
and that we have seen. What do you have to say to this?
Yes, my lord. Now, the thing is that, my lord, the Supreme Court said that later, my lord, not, my lord, during the period of my tender process.
No, it doesn't matter.
No. My process of tender has been completed by 28/3. Supreme Court orders come on 25/7. July, my lord.
Doesn't matter.
How, my lord, this retrospective effect, how the Supreme Court order has the retrospective effect, my lord?
Yeah.
Only this much, my lord, this is the case. Whether Supreme Court order will have
That's an
retrospective
answer.
effect.
You have only answered the question.
Hmm?
No, but since it was not executed,
No,
I
no,
think they've done it.
process has been completed,
What
my
is
lord.
the problem? This time you came as the highest bidder. Next time also you will come as the highest bidder.
My lord, my tender
It
has
was
been,
earlier given to you also for
no, my
7
lord,
years.
my tender has been disclosed, my lord. The value I have put down there in that tender has been disclosed, my lord. Automatically, I have been,
But we can't do anything about it. There is a compulsion.
no, compulsion, my lord, I could not understand, my lord. The Supreme Court order has come later on, my lord. Before that, my process has been completed.
Maybe. But they want it because you see, what are these circulars? They want 100% fisherman certificate.
Yes, all these are
labor
complied with, my lord.
certificate, Purchaser experience. So you're talking about your problems. They understood it from a
No, that 2018 circular has been totally complied, my lord.
no,
Yes, my lord, complied.
no. Where is
Because, yes, my lord.
where is that statement? Where
Yes,
is that statement in your appeal or in the writ petition?
Yes, my lord, yes, my, yes, I'll.
That
say.
it was compliant of the circular of 2018,
Yes, my lord, yes.
notwithstanding the judgment of the Supreme Court. Yes, sir. Yes,
Yes, my, yes, I am coming, my lord.
page 12. No, it was already compliant. तो यही बहस करते हैं आप इतनी लंबी क्यों बहस कर रहे हैं?
If your lordship Perus place,
What do you have to say about this?
my lord, may Perus place 29, my lord. of the
Page
writ
29.
petition, my lord. The tender notice, my lord. There is no clause as such. my lord.
Oh.
Page 29 here. But the contents are there.
Contents are there.
Yes, then.
My lord, that instruction I don't know.
What happened in the first tender that you have issued? Has he participated?
Look, there is,
Yes, President, I have participated.
So wait for the result.
No, my lord, I am not on that, my lord. I have
You
participated.
not on that, but
Otherwise, I
that.
will lose, no, I will lose, my lord, this side also and that side also I will lose.
You cannot lose
I am
it.
not challenging that one, my lord.
Mr. Sinha, you
No, I am not challenging that part, that the second tender, my lord. The tender, I am not challenging that one. But whether it is whether appropriate, my lord, that the Supreme Court order or whatever government notice comes later on after completion of my process, only for that, my lord, appeal has been made. Only for that reason, my lord. Because I have said that in the tender process, the first tender process.
then if you raise that point, we approach it from a different point that you have already participated in the first tender. Don't question.
Yes, that's what I was thinking, but I have
Don't
not challenged,
question.
my lord, that one.
No. Unnecessary. हो जाए. देखिए, the appellants have questioned, the appellant, a society has questioned the judgment dated, so and so, judgment dated 24/10/2025, passed by a learned single judge of this court in WPC number 5987 of 2025, refusing to interfere with the retendering of the fishing rights, even though the tender documents were compliant of the government circular dated 18/1/2018. The appellants had been granted fishing rights in 64 Parghopa fishery way back in the year 2016 for a period of 7 years, which expired on 25/1/2024. The contention of the petitioners is that during this period, the pandemic set in, the COVID pandemic set in, leading to heavy losses. There was growth of hyacinth also in the pond, which disrupted the flow of water. The other cause of loss was by the act of God, namely less rainfall and therefore less water in the pond. Despite this, the petitioners continued with their fishing rights and their obligations towards this state. The government thereafter issued another NIT on 4/3/2025 for settlement of the fishery, for settlement of the fishing rights in the above fishery. The contention of the petitioners is that the NIT was totally compliant of the Gazette notification dated 18/1/2018. The petitioner society participated in the bid and were returned the highest bidder. However, by letter dated 16/8/2025, the fishery, the fishery rights were put to re-tender only on the reason of a Supreme Court decision in Supreme Court decision in Tetali Guri Navajyoti Matsyajivi Samabay Samiti Limited Cooperative Society versus State of Assam and others, wherein it was held that all the tendering authority will insert a clause in all NITs that the government circular dated 18/1/2018 shall be followed as long as the same is in force. The contention of the petitioner, the contention of the petition, actually, appellant society and petitioners. I thought it was a pair. The contention of the appellants before the writ court was that the words, namely government circular dated 18/1/2018, may not have been incorporated in the NIT, but all the conditions in the circular dated 18/1/2018 were inserted in the NIT. There was thus no necessity of putting the fishery to putting the fishery to a re-tender. The learned single judge, based on the direction of the Supreme Court and finding that it was not clearly indicated in the NIT paper that the circular dated 18/1/2018 is in force and shall apply proprio vigor in all such tenders, justified the re-tendering of the fishing rights. During the course of arguments, we have found that in the re-tender, the appellant society has participated. The objection of the appellant is but that in the last tender, the price offered was disclosed. And this will put him to a disadvantageous position in the new tender. However, considering the fact that the petitioner, that the appellant has already participated in the fresh tender and that it was not clearly stated in the tender paper that the conditions which have to be complied with are the conditions which have been enumerated in the government circular dated 18/1/2018, comma, the NIT does not remain compliant for the reason of a different reading and requirement in a standard form contract being necessary, comma, we do not find it necessary to interfere with the judgment of the learned sitting judge. For the reasons stated above, the appeal is dismissed.
All right.
Item 25.
Yes,
May it please your lordship.
this is the second one. Supplementary.
Lord, Northeastern Frontier Railway,
Yes.
they have issued an NIT inviting bids for construction of second rail cum road bridge over River Brahmaputra at the Saraihat, my lord. Now, the dispute is relating to that very tender. Now, my lord, there is a clause in the tender which says that if any of the, whether the bidder in the last 3 years, whether there is any history of collapse. So, my lord, apprehending that they might invoke that clause. So we filed WPC.
Mr. Chaudhary, just give us 2 minutes.
Yes, sir.
Yes.
Yes.
So you did not cross that technical
No,
threshold.
yes, on technical ground, my lord, now we have been rejected. Now, regarding that clause, my lord, in respect of which, when we made an approach in 5051, their lordships will get at page number 83. Sorry, 84, my lord.
Consider, they have considered. Where is it? The second. Where is it? That cancellation, that your technical non-suiting also has been challenged.
Yes.
This is
That-
against
no,
the
my
nature
lord,
of.
what had happened, my lord? What they're taking these steps in phase so that each of our writ petitions become infractuous, then we have to go on filing. Now what after tomorrow they will say agreement has been executed,
No.
then we'll have to.
Where is the other petition? No,
My lord, let me place the facts, my lord.
we'll
First-
hear you tomorrow.
My lord,
Mister, you are ready? Tomorrow? We'll hear you tomorrow.
Tomorrow, Lossi, I pay for first half, Lossi, second half, I will be not available
yes,
in
yes,
first half, Lossi.
no problem.
Let this matter come up for tomorrow.
Yes, yes, yes.
Let this matter come up for consideration. Tomorrow, I think we. put
Then
it
my
on
day after tomorrow also, I will be no difficulty, Lossi. Tomorrow I have some difficulties.
Friday.
Lossi, Lossi.
Friday.
My lord, let it be tomorrow, my lord. There's some urgency because they might execute the agreement, these and that. Then tomorrow our second writ petition will become infractuous. My lord, it's a case where I will.
The difficulty, Mr. Chaudhary, is this.
Yes.
Now, this appeal is against an interlocutory, I mean, an order.
No, what we say, my lord,
They have issued the LOA is okay. Now, until our appeal and the other writ petition is heard, they should not proceed further. That's our only thing, my lord. And construction of bridge over mighty river Brahmaputra, it will take at least 3 to 4 years. So for another 15 days, heaven is not going to fall. All that we are praying for is, my lord, whatever they have done,
In
done.
fact, when you use that expression before the land single judge, that was incorporated in the order.
Lordship,
That heavens ought not to fall, heavens may not fall, but then there is something called urgency.
No, my lord, that we appreciate. That we are not coming in the way.
But you have again used that expression.
No, my lord, my humble submission is, there was a direction by the learned single judge.
Hear it day after tomorrow.
after tomorrow.
Let this matter come up for consideration on
19th.
Huh?
19th. 19th.
19th.
Item 18 and 19.
Which is to be crying here.
ওপৰত কোনটো আছে?
Yes.
My lord, there are two writ appeals. In writ appeal, my lord, item number 18, we have challenged the order of the learned single judge, my lord, whereby the learned single judge has interfered with the order passed by the state level scrutiny committee. And in the second appeal, my lord, in terms of subpara 13 of Madhuri Patil, my lord, we said that some action should be taken against respondent number 3, who is the mother, who is a police officer.
And that has not.
At there, my lord, my writ petition has been dismissed on the ground that we do not have the necessary locus. That there is no, violation of any legal right of ours. Therefore, a mandamus should not lie. That is the finding there. My lord, if your lordship should kindly take the first appeal, that is writ appeal number
5.
5, my lord.
Yes.
Yes. Now, my lord, let me place first of all the order passed by the state level scrutiny committee, which was put to challenge by the other side before the learned single judge and which came to be interfered with at page number 59. It starts at page 57, my lord. The operative portion is at page 59.
Just a minute.
On the last page, well, I anticipate the 2-page, it is not
There's.
incorporated in the order also.
Okay, no, right.
After careful perusal and examination of all records,
Yes.
personal hearing of Srimati Leena Dole, mother of Divya A. Lahan, and Sri Gaurav Upadhyay, and analysis of the evidence and observations, state level scrutiny committee finds as under. Although Miss MS Vidya A. Lahan is the offspring of a marriage between a tribal, that is Srimati Leena Dole, the mother, and a non-tribal, late Nilutpal Lahan, the father, and she has been brought up by her mother Leena Dole, there is no evidence that Divya A. Lahan suffered disabilities, social, economical, and educational cumulatively. Mrs. Srimati Leena Dole is an APS officer belonging to class 1 cadre in the government of Assam. She has provided good educational facilities to her daughter in reputed schools of the state. The statements provided by members of the missing community, that is Parneswar Dole, President All Guwahati Missing Kabeng, and Ranjit Kumar Dole, which are available on record, merely state that children of Srimati Leena Dole belong to missing community, and the said statement do not substantiate anything regarding their tribal custom, way of life, etc. of the children, or the children of Srimati Leena Dole suffered disadvantage or disability due to their mother's ST status. On the contrary, the vigilance report has found that though Srimati Leena Dole belongs to missing community and originally hails from Lakhimpur district, she had only little communication link with the people of her native village. The available evidence suggests that good education and amenities were made available and accessible to Miss Dibya A. Lahan, and that the condition that by virtue of being a daughter of a forward class father, she did not have any advantage start in life, but on this contrary suffered deprivation, indignities, humilities, and handicaps like any other member of the community to which her mother belonged, is not fulfilled in her case. Accordingly, the state level scrutiny committee is of the view that MS Dibya A. Lahan, daughter of Lina Dole, does not belong to scheduled tribe community of Assam. So this order has been interfered with by the learned single judgment on grounds which I respectfully submit is absolutely erroneous. Now the learned single judge has taken the view that because her mother is tribal, that is good enough.
Because her mother is?
A tribal.
No, no.
Yes.
So many pages can be devoted to this simple proposition.
No, yes. Because rewriting Valsama, which was overruled by the Supreme Court. The learned single judge's judgment,
Where
my
is the
lord,
judgment?
at page 535.
Now tell us page, my brief has, you know, the impugned judgment in the top. So you tell me the paragraph.
Okay, okay, I'll just read it.
Tell me the paragraph.
1 second. Please come to me, Lord. Paragraph 55, internal page 51.
Yes. 55.
Yes.
And before that,
Para 55.
now let's see what he has.
Or let
gathered
us
from
let us
different
start from below
54.
page 50. Para 54, yes.
Para 54, yes.
From the above conclusion of the Supreme Court, what is required to be shown and proved in the case of offspring of a forward father and scheduled tribe mother are offspring was brought up by mother who belongs to scheduled tribe community. The offspring being born to a forward caste father, the offspring did not have any advantageous start in life. On the contrary, suffered the deprivations, indignities, humiliations, and handicaps like any other member of the community to which his or her mother belonged. Offspring was always treated as a member of community to which her mother belonged, not only by that of the community, but by the people outside the community as well, meaning thereby that the offspring is identified with the mother's community and the father. In the present facts, it would be seen that the petitioner number 1, along with her brother, were raised by the mother solely, who admittedly belonged to scheduled tribe community since at their ages at 6 and 2, when their father had expired. The vigilance report does not in any manner state that the petitioner number 1, along with their brother, were living with their paternal grandparents. On the other hand, the report categorically mentions that both the children of the petitioner number 2 have been raised by the petitioner number 2. Under such circumstances, the first condition of the test laid down in Ramesh Bhai is met. I'm sorry, my lord, nowhere Ramesh Bhai has held any such proposition. Let this court now take up the second criteria to be satisfied. In the earlier segments of the judgment, this court has extensively dealt with the deprivation, discrimination, indignities, humilities, and handicaps faced by the backward disadvantaged class. This court had dealt with the socio-cultural disadvantages faced by citizens belonging to disadvantaged backward classes, which is on account of the iniquities and deprivations faced by them since century. Therefore, deprivation and discrimination felt, indignities and humiliations faced, and handicaps on account thereof are ingrained in the characteristics of backward disadvantaged classes. Can you see the approach, my lord? In the said backdrop, if a child, as in the instant case, is brought up in such an environment and community which had already suffered and is suffering the deprivation, humiliation, indignities, and handicaps, the child would automatically be enduring the deprivation, humilities, and indignation and handicaps. To substantiate the above proposition, let this court take the reverse analogy. What would be the status of a child born to a scheduled tribe father and a forward class mother, where the father expired when the children were 6 and 2 respectively, and the mother had raised and is raising the children in a forward class environment? In such a situation, children would have an advantage being brought up in a forward class environment, wherein deprivation, humilities, indignities, and handicaps are not felt. Apart from that, the children would also not face any socio-cultural disadvantage. Under such circumstances, if the children are granted scheduled tribe status, merely being born of scheduled tribe father, it would result in rendering the constitutional scheme of substantive equality redundant, inasmuch as special treatment which is meant to be for upliftment of the backward classes as a homogeneous group would become redundant. In this regard, let this court take another example of a case where an orphan is raised by a scheduled tribe father alone, or a scheduled tribe mother alone, or even by a couple who are scheduled tribe from a very tender age in the atmosphere and community of a scheduled tribe. Can it be said that orphan would not be entitled to claim reservations or special treatment on account of his or father's ancestry being unknown? In the opinion of this court, the said orphan would be entitled to the benefits of special treatment belonging to the scheduled tribe, as he has been raised and brought up in a scheduled tribe environment and community which had already suffered and is suffering deprivation, humilities, indignities, and handicap. The above basis can be seen at para 19 and 20 of the judgment of the learned full bench of the Kerala High Court in case of so and so, and para 48 of the Ramesh Bhai, which have been quoted here in above. My lord, in Ramesh Bhai, my lord, the underlying principle which has been laid down is, in such a situation, there would be a presumption that the child takes the caste of the father. But that presumption is not final, my lord. It is only a rebuttable presumption. End of the day, it will all depend upon the facts and circumstances of each case.
That's
Yes,
they say.
attending each case. My lord, para 48, where a question was posed by the Honorable Supreme Court in Ramesh Bhai. Para 48, nowhere any proposition of law as such as is ought to be inferred was laid down, my lord. We'll place it.
Proposition of law which has been laid down and the conditions which have to be satisfied
Yes.
are in para 54 and
Correct,
55.
absolutely. To that extent, there is nothing wrong, my lord. But to say that those conditions are fulfilled here, having read the my lord SLEC's report, in my humble submission is not correct, my lord. Now, lordship has seen the approach from para 55 onwards, as if somebody is born and brought up, then that is good enough. Now, here, where are the evidence they were born and brought up? They were born and brought up, they were studying in best of the schools, they never suffered any indignities, they never suffered any disadvantage in life. And moreover, their father is not a tribal. So that is why the test becomes relevant. Therefore, at page 587, my lord, the above analysis would...
You have Dabhai Naika
Yes, yes.
before you.
Yes, yes. My lord, we have given a compilation, my lord.
Compilation today, yeah.
Not a compilation that they have...
पहले वाला केस में compilation था ना? वो दे देना हमारे पास फिर.
My lord, we have made a compilation, my lord. Apa ano ko diya? Ko diya na? Anjan. My lord, this is at page 87 of the compilation.
I have a loose copy of this. You read from that paragraph.
Yes. My lord, first I will request your lordship to read the very first para, my lord.
No, that we have seen.
Facts of the case. Just small paragraph of Ramesh Bhai.
I've seen that.
Okay.
Now let us see. Come to 54 and 55.
54 and 55. Yes.
These are conclusive
Yeah,
paragraphs.
absolutely, absolutely. In view of the analysis of the earlier decisions and the discussions made above, the legal position that seems to emerge is that in an intercaste marriage or marriage between a tribal and a non-tribal, the determination of caste of the offspring is essentially a question of fact to be decided on the basis of the facts adduced in each case. The determination of caste of a person born of an intercaste marriage or marriage between a tribal and non-tribal cannot be determined in complete disregard of the attending facts and circumstances. Lordship has just now used that expression. In an intercaste marriage or a marriage between a tribal and a non-tribal, there may be presumption that the child has the caste of the father. This presumption may be stronger in the case where the intercaste marriage or marriage between a tribal and a non-tribal and the husband belongs to a forward caste. But by no means the presumption is conclusive or irrebuttable, and it is open to the child of such marriage to lead evidence to show that he has been brought up by the mother who belonged to scheduled caste, scheduled tribe. By virtue of being the son of a forward caste father, he did not have any advantage start in life, but on the contrary suffered the deprivations, indignities, humilities, handicaps, like any other member of the community to which his or her mother belonged. Additionally,
Now,
that he was
this is what has been taken by the learned single judge. So he says additionally, that he was always treated as a member of the community to
Yes.
which her mother belonged.
yes,
Not only by that community, but
Ah.
by the people outside the community as well.
yes.
So on this
In
score,
fact, my lord,
on this score only, it has been remitted.
my lord, in fact, here is a case. They were general till the other day. In
Well-
this, and we have annexed all the documents in it. My lord, in fact, she took pride, respondents, by saying that though my children are from my side, but we have treated them as general caste. In fact, in school and all, my lord, they were all the general caste. They studied in Kendra Vidyalaya Sangathan, where, my lord, the certificates we have annexed.
No, but tell me one thing, Mr. Chaudhary.
And presently, my lord, she is studying in Miranda House under the general category.
No, that's all right.
Yes.
No, we are not on that.
Uh-huh.
We are not on the correctness of the
Yes,
report or the
yes,
judgment.
yes.
Now we are at the stage where this court is there for the opinion.
Yes.
So the matter requires to be remanded to the SLC to decide only on the aspect. that
Yes,
the
yes.
people- So the time limit was given 45 days.
Yes.
Have they
There's
come
a
up with-
stay, there's a stay order, my lord.
Who is it? Here.
Yes.
Not all suffering.
There's a stay order.
Now you argue, Mr. Chaudhary, on, I mean, what is arguable? These concepts we understand.
Yes.
Valsamma and Anjan and
My lord, if we go by the case laws, then what will emerge?
case laws is something different.
Yes.
What you are supposed to argue and what Mr.
Yes,
Sharma is to defend.
All that I will,
What Mr. Sharma is to defend and what you have to argue is
yes.
that whether this could have been remanded when the state level caste scrutiny committee
Yes.
had examined the matter.
Yes.
Right.
There, my lord, first,
ये बहस करिए,
yes.
सब सुनते हैं, otherwise law
Yes.
is very clear now.
Yes, yes. Now, my lord, first I will place, my lord, now facts are clear. The law is very
Facts are
clear.
not clear, the law is clear.
No, facts are clear, my lord. There, my lord, a certificate was issued.
IPS officers. They
No, one is IS officer, IPS.
Both
And now the IC has also been nominated.
He's APS, we are.
Also, our client is an IPS officer. She is an APS, Assam Police, State
right.
Police.
The other person also is the respondent also is a police officer,
Yes,
IPS officer.
yes, yes. It's not difficult. Now, my lord, initially she obtained the certificate. Then we complained. Then, my lord, state level scrutiny committee cancelled this certificate. They approached the honorable single judge. Honorable single judge has passed the impugned order. We are before your lordship. These are the facts. Now, the question of law is, my lord, as it appears from para 55 of Ramesh Bhai, my lord, that in a case where a tribal is married to a non-tribal, their offspring can still claim the certificate of the mother, provided they prove the conditions as laid down therein. Now, my lord, I have demonstrated from the findings of the state level scrutiny committee that nothing of this such, even, my lord, that part also is there. Because other than saying they adduced two evidence in their favor, two gentlemen, one president and one office bearer of a particular association of Guwahati. All that they said was that her mother is a scheduled tribe. Other than that, nothing has been adduced. So,
Not undergone.
Yes.
if your lordship should kindly take the trouble of coming to page 59 for a moment, Miller. Well, very crucial in this case, Miller. There is somewhere in the sixth line, the statements 1, 2, 3, 4, 5, yes, sixth statement, line. The statement provided by members of the missing community, that is Sri Korneswar Doloi, President All Guwahati Missing Kabeng and Sri Ranjit Kumar Dole, which are available on record merely state that the children of Srimati Leena Dole belong to missing community, and the said statement do not substantiate anything regarding tribal custom, way of life, etc. of the children, or that the children of Srimati Leena Dole suffered a disadvantage or disability due to their mother's status as ST status. On the contrary, vigilance report has found that though Srimati Leena Dole belongs to missing community and originally hailed from Rosping district, she had only little communication link with her people of the native village. The available evidence suggests that good education and amenities were made available and accessible to Dibya Lahan, and that the condition that by virtue of being daughter of a forward caste father, why is that? Is it the case of the court that at that point there's a picture. Now, if on this point there is a finding, then we can still be.
Now, we would like to know from you two facts. What is the stage of the criminal case now?
Charges has been framed.
Minus the SC/ST. But POCSO charges have been framed. Anyway, yes.
Now, my lord, having gone through Ramesh Bhai and all other authorities, my lord, my humble understanding, subject to the lordship may say, my lord, that suffering, indignities, disadvantage, starting life, etc., etc., these are the main consideration. My lord, I don't find anything in the Madhuri Patel or subsequent judgments that if the finding is recorded by the state level scrutiny committee, that members of the community regards him as such, that itself, that alone will be a decisive. I don't think, my lord, that emanates from any of the authorities of the Supreme Court. And that is the precise view of the learned single judge. Learned single judge basically accepts the proposition that once you are a daughter of a scheduled tribe, and from the age of 6 and 2, you are being brought up by their mother, that is enough. That is what one Valsamma said, once you are married to a lower caste man, then you can become a lower caste man. That was the Supreme Court says that is wrong. In Sobha's case, Supreme Court says it can't be done. So end of the day, it has to be seen in the facts of each and every case. It is not that an offshoot of an intercaste marriage cannot stake the claim of the mother. Of course it can be, but provided these conditions are satisfied. Now, therefore, my first submission would be, once a state level scrutiny committee has rendered a finding, now, what is the extent of scope of judicial review?
No, what was, yeah, that is the question that we wanted to know.
Yes, yes.
But tell me one thing.
Yes.
This WA number 388 was filed first, or WA, you filed this Madhuri Patil thing. Therefore, they had to file this. You filed this Madhuri Patil. In fact, it's a battle between two police officers. Unnecessarily, the children are being made victims.
Absolutely. Unfortunately.
Children are being made victims. It'll.
My learned friend is saying unfortunate.
But of course, my lord, the daughter, my lord, who I represent also, my lord, she was admitted in, otherwise would have got an admission in Stephens. I took the admission, my lord, withdrew. Now I'm in Miranda, my lord. I'm missing
As
Stephens.
good institution, as good.
Well, of course, no doubt, but Stephens is Stephens. Who better than your lordship should know?
I think my learned friend should place the Carifex. She has not withdrawn, my lord. It has been cancelled.
No, Malad, I
Because
I
she has
withdrew from
used,
there.
she has used the cancelled certificate.
Got to know, Malad,
And
it's a
police case is
mistake.
going
I
on.
withdrew. That's a
Police-
separate matter. I'll deal.
Police case is going on, my lord. In New Delhi, police case is going on this. National Commission for,
Mr.
anyway, that's a
Sharma,
different
yes,
aspect. But since my learned friend brought out there, otherwise I have a,
POCSO is more stringent than SCST.
yes.
Yes, Malad.
So
The High
where
Court
is
is-
the dispute? Why are you fighting that the case continues? Prosecute him in criminal case.
Yes, Malad. I have no difficulty.
Although that is continuing.
Yes, and this honorable court by an order has stayed, Malad, the invocation of the provisions of the ST Act, Malad.
So where
And
is the
therefore in the
dispute?
charge
Now, what do
sheet,
you want? What action do you want?
absolutely, Malad, no
Mr. Chaudhary,
prejudice.
what action?
No, my lord, she is not an ST. Simple as that. She is not an ST, she cannot claim that. Number one. And number two, my lord, the mother should face disciplinary proceeding as per Madhuri Patel's dicta.
Therefore I say,
Yes.
you have filed this appeal, therefore
Yes,
this
yes.
litigation.
Uh.
They would also have been satisfied.
My lord,
They would also have been satisfied with the decision. I mean, they would have been satisfied in the sense that they would not have pursued it further.
Can I make a small statement, Malad, here, based on instruction? Malad, I am saying so, Malad, that I will not press, Malad, this ST Act, Malad, as far as my learned friends' clients are concerned. No difficulty. Even in the criminal proceeding.
Because the other provisions are more stringent.
prosecution will say that, my lord. Where is the question of my learned friend saying?
Malad,
"I'll not
I
place
have
into
put in that,
service"?
Malad.
I don't think that makes any sense, my lord. At the end of the day, it is prosecution who will lead the case.
Now they are important mouthpiece of prosecution. No, it is prosecution on their behalf.
Correct.
I don't know why this was continued, but nonetheless, the issue has come up before us. We will decide it.
Yes, yes. So, my lord, therefore, first I'll like to place two judgments on the point, my lord. Why this learned single judge ought to have not interfered in this case, my lord?
Yeah, this argument.
Yes,
Yeah, no.
yes, yes.
More or less, we are conversant
Yes,
with the
yes,
facts.
yes.
Huh?
Now, please, in the compilation, please come to page 32, my lord.
Which?
32 of the compilation. This is Anjan Kumar versus Union of India.
That's again an SC/ST status.
Yes.
No, but
No, my lord. On the scope of judicial review, my lord, against an order of my lord,
okay.
state level scrutiny committee.
Okay.
Please come to page 40, para 14 and 15.
Page 40.
Page 40, para 14 and 15. In view of the catena of decisions of this court, the questions raised before us are no longer res integra. The condition precedent for granting tribe certificate being that one must suffer disabilities wherefrom one belongs, the offshoot of the wedlock of a tribal woman married to a non-tribal husband, forward class, cannot claim scheduled tribe status. The reason being such offshoot was brought up in an atmosphere of forward class and he is not subjected to any disability. A person not belonging to scheduled caste or scheduled tribe claiming himself to be a member of such class by procuring a bogus caste certificate is a fraud under the Constitution of India. The impact of procuring a fake bogus caste certificate and obtaining the appointment admission from the reserve quota will have a far-reaching grave consequences. A meritorious reserve candidate may be deprived of reserve category for whom the post is reserved. The reserve post will go into the hands of non-deserving candidate. In such cases, it would be violative of the mandate of Article 14 and 21 of the Constitution. The scheduled caste and scheduled tribe certificate is not a bounty to be distributed. To sustain the claim, one must show that she has suffered disabilities socially, economically, educationally, cumulatively. The authority concerned before whom such claim is made is duty bound to satisfy itself that the applicant suffered disabilities socially, economically, and educationally before such certificate is issued. Any authority concerned issuing such certificate in a routine manner would be committing dereliction of the constitutional duty. So these are the clear authorities, my lord. Then, my lord. এইটো কোনটো জাজমেন্ট আছিলে যিটো কৈছিলে এই যে মানে ইন্টাৰফেয়াৰ কৰিব নালাগে one second. Yes. Could your lordships kindly have, my lord, 2024 SCC online SC 494.
Page.
Navneet Kaur, my lord, it is not part of the compilation, I think, my lord.
We have loose copy of it.
Yes, yes,
Is the same Navneet Kaur Rana the political leader?
yes.
Huh? Same leader. Sure.
Now, please come to para 15, my lord.
One second.
I'm sorry.
We'll have to search for it, no?
Oh.
Yes.
Please come to para 15, my lord. Now, this is an authority for the proposition, my lord, in what situation High Court would be justified in interfering with the scrutiny committee's findings.
Para 15.
15. Now, when the scrutiny committee, which is principally tasked with the fact-finding exercise for validation of a caste claim, had applied its mind and reached a conclusion, then in such a situation, whether a roving inquiry by High Court was required. It is well settled that the High Court as well as Supreme Court should refrain themselves from deeper probe into factual issues like an appellate body, unless the inferences made by the concerned authority suffers from perversity on the face of it or are impermissible in the eyes of law. In the instant case, the order passed by the scrutiny committee reflects due appreciation of evidence and application of mind, and in the absence of any allegation of bias, malice, or lack of jurisdiction, the disturbing finding of the scrutiny committee cannot be sustained. Then, my lord, will kindly come to paragraph 17, my lord. Having perused the order passed by the scrutiny committee and findings recorded by it to reach its subjective satisfaction with
Yes. Yes.
Para 17, my lord. Having perused the order passed by the scrutiny committee and findings recorded by it to reach its subjective satisfaction with respect to the claim of the appellant at this juncture, if we look at the whole exercise carried out by the High Court from the perspective of settled principles of law for invocation of the jurisdiction under Article 226 of the Constitution of India, particularly in relation to writ of certiorari, it leaves us with no scope of doubt that the High Court has clearly overstepped by reappreciating the evidence in the absence of any allegation of malafide or perversity. As fairly settled by this court in Catena of Judgment, writ of certiorari being a writ of high prerogative should not be invoked on mere asking. Purpose of a writ of certiorari for a superior court is not to review or reweigh the evidence to adjudicate unless warranted. Jurisdiction is supervisory, and court exercising it ought to refrain to act as an appellate court unless the facts so warrant. It also ought not to reappreciate the evidence and substitute its own conclusion, interfering with the findings unless perverse. The High Court in the writ of certiorari should not interfere with such challenge is on the ground of insufficiency or adequacy of material to sustain the impugned finding. Assessment of adequacy or sufficiency of evidence in the case in hand fell within the exclusive jurisdiction of the scrutiny committee, and re-agitation of the challenge on such ground ought not to have been entertained by the High Court in a routine manner. Then Lordship may kindly skip para 18, come to 19, my lord. In sum and substance, the writ of certiorari is extended as a remedy and is intended to cure jurisdictional error, if any, committed by the court's forum below. It should not be used by superior court to substitute its own view by getting into fact-finding exercise unless warranted. At this juncture, it would also be profitable to refer to relevant extract from the judgment delivered by this court in Indian Overseas Bank. The finding of a fact recorded by a fact-finding authority duly considered for the purpose and which ordinarily should be considered to have become final cannot be disturbed for the mere reason of having been based on material or evidence not sufficient or credible in the opinion of the writ court. You warrant those findings at any rate, as long as they are based upon such materials which are relevant for the purpose, or even on the ground, there is yet another view which can reasonably and possibly be undertaken. Such being the situation in the instant case, High Court went into probe regarding credibility of the opinion of the scrutiny committee because the writ court felt the need to substitute its own view. In case if the finding of the scrutiny committee are based on material specified under Rule 16, followed by subjective satisfaction, then exercise of jurisdiction under writ of certiorari to pass the order of validation of the caste claim by the scrutiny committee is unwarranted and uncalled for. Then, my lord, finally, paragraph 22, my lord. In view of the aforesaid discussion, we are of the considered opinion that High Court inadvertently undertook an erroneous exercise of appreciating evidence in exercise of its jurisdiction under Article 226 and swayed itself into a roving inquiry which was not expected as per the settled legal position. At the cost of repetition, we again observe that under Rule so-and-so, the adjudication on the basis of document falls solely within the domain of the scrutiny committee based on the inputs received from the vigilance cell. The scrutiny committee is an expert forum armed with the fact-finding authority. High Court ought not to have interfered, especially when scrutiny committee had followed the due procedure under Rule so-and-so, and that there was nothing perverse about a finding of fact. In the instant case, the scrutiny committee duly considered the documents placed before it, and after due application of mind on being satisfied, accorded reasons for accepting, validating the caste claim of the appellant therein, while appreciating, rejecting other certain documents. The scrutiny committee heard all the parties in detail, complying with the principles of natural justice. Hence, in our considered opinion, the order of the scrutiny committee did not merit any interference by the High Court in a writ of certiorari under Article 226 of the Constitution of India. My lord, having regard to the proposition laid down in the judgment, now if we test the views of the learned single judge, what we will find is, my lord, not only the learned single judge has discarded the factual findings arrived at by the scrutiny committee based on evidence on record, the learned single judge has, my lord, tried to brought in the concept of a tribal mother having two children who are born and brought up in a tribal family would automatically become a scheduled caste, despite the fact the father is a forward caste. Where from this emerges, my lord?
No.
Paragraph 55 and 56, in fact, the approach is that.
How do you say that?
Yes, please come again, my lord, also. Please come to me, lord. Para 56.
Judgment से कुछ ठीक से रखो एक जगह करके
Please come to para 56, my lord. Let this court now take up the second criteria to be satisfied. In the earlier segment of the judgment, this
start from para 55 is
no,
para 50
I'll read para 56 and 58, my lord.
Achha, start with para 55, one
Okay.
paragraph, short paragraph.
Yes. In the present facts, it would be seen that petitioner number 1, along with her brother, were raised by the mother solely who admittedly belongs to scheduled tribe, and since their ages at 6 and 2 when their father had expired. The vigilance report does not in any manner state that the petitioner number 1, along with her brother, were living with their paternal grandparents. On the other hand, the report categorically mentions that both the children of petitioner number 2 had been raised by the petitioner number 2 Under such circumstances, the first condition. Now let us test this para. Now merely because.
This paragraph is all right. This is no roving inquiry. This is only
No,
testing.
No, no, my lord, trying to test it.
Huh.
No, my lord,
No, can
the-
you stop that?
Ah.
Now,
The
can
inf-
Mr. Chaudhary make a submission that no, even reading Navneet Kaur, the paragraph that you quoted,
Yes.
heavily loaded,
Yes.
heavily loaded. But question is this, now there is no forum. So 226 automatically gets attracted.
True.
And if
No, I'm not saying, my lord, this subjective, whenever there is any question of any subjective satisfaction, my lord, it is always open
That's
to
all right.
judicial review.
Yes.
But the question is, what are the, my
To
lord,
what extent?
Lakshman Rekha?
To
But-
what extent?
To what extent?
Okay. So therefore, the three conditions in Dabhai Naika are that he should be brought up by the mother, tribal mother. Number two, should not have an advantageous start. And three, it should be perceived from
By others.
By others. These are three conditions.
Yes.
These are tests.
Yes.
Because this Naika.
No, to that
makes it
extent,
very-
there is nothing wrong.
So therefore, if the court finds that first two conditions are met, the third is not there. So go for it.
No, my lord. No, my lord. True.
I mean, we are speaking at the worst.
Yes. No, my lord, my humble submission is very simple.
In fact,
Now,
once the order was passed, we are of the view at the moment that it should not have been. It's all our tentative views, Mr. Chaudhary. We say this only for concretizing our opinion. It should have only 45 days were given to the state legal. It should not have been stayed. Under no circumstance, because this law also has been settled that if a small window is given, please let it happen.
No, my lord, my humble submission is otherwise. Please appreciate, my lord. Now, 1, 2, 3 as a proposition of law, absolutely no problem. But question is, when we apply these propositions to the facts of the present case, what emerges?
Why should we do? The mistake committed by single judge, you want the mistake to be committed by us.
Oh, no.
We are on a different issue. It's a different thing. Forget the facts of your case. Now, there is a report by a statutory committee.
Yes.
Committee formulates its report based on evidence collected. There is no higher forum 226. I don't think this would be this could be writ of certiorari, but then in that case, the court looks at it. And court finds that the three indices on which it could have been decided properly and correctly, two of them are there. One is not there. So why not send it to them to do it? You may say that the Lakshman Rekha has been crossed.
No, Lord.
Just
My
let-
humble
let me-
submission
let
is
me-
that
let-
finding is also there.
Let me
At
complete.
page
That
59.
finding also is there, is agreed.
Huh.
So therefore, this was wrong.
Yes.
So in any view of the matter, when 45 days was given for further confirmation, that should have been allowed to continue.
No, my lord. With all respect, my lord, that was there. That is ingrained. I'm using the word of the learned
Okay.
single judge. That finding is ingrained in page 59.
Okay.
That's why, my lord,
Ah.
learned single judge is trying to substitute the view of the scrutiny committee.
This argument you can definitely.
Yes. It's a case where learned single judge, my lord, purportedly substituted the views of the scrutiny committee. Because that finding is there. Other than saying that she belongs to missing community, there is no other evidence. She haven't bothered to go to their native place. That's the finding. Her native place is in North Lakhimpur. She has never gone there. That's the finding. So, my lord, where is the scope? That finding is also there. That view of the position, my lord, is it
This
not
was-
a case
that was page 56.
59, my lord? Line about 6 from bottom, sorry, my lord, line above that.
Just
On the contrary,
Oh, one second.
yes. Line about a 9 from the top, my lord, sentence starting with on the contrary. On the contrary, the vigilance report has found that though Srimati Leena Dole belongs to missing community and originally hails from North Lakhimpur district, she had only little connection link with the people of her native village. The available evidence suggests that good education and amenities were made available and accessible to so-and-so, and that the conditions that by virtue of being a daughter of forward caste father, she did not have any advantage start in life but on the contrary suffered the deprivation, indignities, humilities, and handicap like any other member of the community to which her mother belonged, is not fulfilled in her case.
No, that's right. Where is the third condition ingrained?
This were, my lord, that now the third, well, that she should be accepted as such by the community and by the
Outside
people
the
at large.
community and in community.
Yes. Now the
Outside the
question,
community also.
yes, by any, but including for forward committee also. It says, my lord, she doesn't have any connection. That means she is not mingling with their type of people.
No connection with her tribe,
Hmm.
but connection outside the tribe. Whether people, that's what
Single judge.
that judgment says. Nika
Yes.
says.
No, my lord.
Nika says that.
Huh. Now, let us read, I mean, Ramesh bhai for a moment, my lord.
Additionally, that he
Kindly
was
see, my lord, page number, it
Internal-
starts at 87, 112 of the compilation. Huh.
Tell me the fact.
Additionally, that he was always treated as a member of the community to which her mother belonged, not only by that community, but by the people outside the community as
This
well.
is what, this is the, no, she may not be having any communication with missing. Communication with other people, that is missing. Of course, this is a very in-depth inquiry.
My lord, if your lordship kindly permits me, I would like to place one document regarding the, since we are talking about community, my lord. Please have the Facebook. Yes. কি কোড গুছি ফেলবো তোকে? নিকোলা মাদা। My lord will kindly come to page number 474, my lord. My lord, please come to page 474.
474.
Yes.
Second volume.
Second volume, my lord.
Four
474.
Does here.
I haven't categorized my children. I have categorized my children as general caste. As a single mother and as an STP, I can certainly apply for the same category as me. As STP or my late husband who was an OBC, I do not believe in caste system and reservation policy. This is my humble contribution to the casteless unreserved population for India. People may of course beg to differ, but this is my belief and change I can contribute to the system. My children will flourish just as they are. That's my belief in them and their talents. Now, where is the question of society thinking otherwise, my lord?
She is a forward-looking person, agreed. But the children, because of the descent, may not be.
Optimum number of posts are there. I'm only referring to one. So in these fact situation, my lord,
On behalf of her daughter.
at least in these fact situation, my lord, for the society to have a opinion.
Now that she has got into IPS, or she was in the APS otherwise, well, of the rank of.
She's still in APS, my lord. Now, my lord, I'll just read 2-3 more, my lord. Into case the importance of them. Page.
Mr. Chaudhary, how long will you take?
I'll take about half an hour, my lord.
And you, Mr. Sharma?
Malad, about 40 minutes, Malad.
Make your arguments concise on the next date. but we are not giving you a long date.
No, no, no.
We'll be finishing it because it
Lordship
is-
will I was thinking I'll stay over and finish this if possible, Malad. I have morning half available, Malad.
No, don't ask for morning. Tomorrow.
Very. I'll make myself available.
My lord, if it is not, can it be started 2 o'clock, my lord? I'll take about half an hour. My learned friend can conclude.
Oh, yeah. 2 o'clock tomorrow.
Wait.
सबको ठीक से करो First,
Note for 7
the committee, now the order has been stayed, you are nobody. You have to do whatever you have to do. And you have done whatever you have to do. Now we will, in case we find that the remand is good, okay, what do you have to say? Either remand or no remand. So how are you concerned? So therefore, if you are here, well and good. Otherwise, it's okay. You ask your junior to be here, he or she will take down the argument. But we don't want to unnecessarily linger it. It has been pending for so long unnecessarily. And you know why? The reason is that it concerns a child. I mean, she may not have remained a child. Now they are taking her name. Everywhere in the record, her name also appears. That is not proper. There is a right to be forgotten. In fact, this fight between 2 police officers, the children later would blame them, blame the parents. Everybody has a right to be forgotten. Why to get involved into this, right? This case happened, all right. This kind of, this kind of hostility pays you nothing. I mean, this is not to you, this is for them.
Correct.
But we are only this kind of, but good sense prevails only after everything is over and down.
Right.
Otherwise, the world would not have been so difficult place to live. It's absolutely unnecessary. Anyway, we can't decide cases on our moral groundings. Whatever arguments you people will raise, we'll have to, answer that.
And we lawyers would be out of job, Malad.
That is why it is said, my lord, what is just may not be legal, what is legal may not be just.
May not be just. But then this is fetching nothing to anybody.
I'm under instructions on that aspect, Malad. We are not going to press that. I mean, if my learned
No.
friend may consider that tomorrow.
Mr. Sharma, you don't have to say that. The reason is that you may not pitch in evidence, but then you're no one to decide.
I understand. Great.
You may not pitch in evidence. That's
Correct.
true.
Correct.
Right. Or you could have said that none of us, we will not prosecute each other. Or the state will take a call under the old 321. I don't know which is the new corresponding provision.
Correct.
Which is the new corresponding provision of old 321.
Correct.
Withdrawal.
We can explore, my lord.
You
Why
want?
not?
Malad, that part is a issue, Malad. Because there is a
Let my learned friend have the
severe
instruction on
allegation.
that also, my
That
lord.
instruction I have, Malad.
Take the instruction.
Hmm.
Whether, see, this is no resolution of time. Normally, of course, in such matters, because it involves criminal case, it involves 376 charge,
Yeah.
it involves POXO charge, therefore it can't be mediated like this. So if the criminal case were not there, we would have forced not forced, we would have forced you to think 5 times
Absolutely.
for settlement. But here we can't do it. It has to come from your side, and you also can't do it because the prosecution now is in the hands of, this cannot be done.
But it's 360 in the new act. I'm grateful to my lord. It is there.
Well, that is purely in the domain of the government. Okay, we'll see.